Hello, and today I want to talk to you a bit about recklessness, in particular the Cunningham recklessness. So let us go back a few steps before looking at recklessness, and let's talk about criminal law in general. In order to establish a crime, we have to prove the actus reus, i.e. the doing, the action that is criminal, as well as the state of mind, the mens rea. Now, mens rea, there can be different types. The most culpable type of mens rea is that of intention. But the second one down from there is recklessness, and that is where recklessness fits in as a whole. Recklessness is about risk taking, it's about knowing that there's a risk but still going ahead and taking the risk. Now, there are different types of recklessness. So in my other video, we'll talk about the Cold War recklessness. Then in my other video, we'll talk about the present type of recklessness, which is essentially the Cunningham recklessness. And in this one, we're going to talk about the original, the very first type, which is the Cunningham recklessness. So let's start with the case where this was established. That is R and Cunningham, 1957. What happened in this case? Well, the defendant broke into a gas meter in order to steal some money. As a result, the gas pipe got fractured and it endangered the victim's life because of the gas that came out of it. So the trial judge basically said that malicious should be interpreted to mean wickedness. However, the defendant appealed, and the higher court, I can't remember, is it the Court of Appeal or the House of Lords? I think it's the House of Lords. I can check for you. But the House of Lords, what they said, I'm pretty sure it's the House of Lords. What they said is that that's not what maliciously means. Maliciously means that the defendant has a subjective understanding of the risk and still goes ahead and takes it. So from this case, we have developed a test of recklessness, which is a subjective test, and it has two limbs. So the first limb is that the defendant must be aware of the risk. They have to know that there's a risk. And the second limb is that the risk that they took and that they were aware of was unreasonable or unjustified to take. Now, the second limb of the test is more objective because it's not looking at whether the defendant saw it was reasonable. It's more to do with would any ordinary reasonable person deduce this risk to be justified or reasonable. But it's still a subjective test because it's looking solely at whether the defendant was aware of the risk in the first place, which when we compare to Caldwell, we'll see is an objective test. So the best way in order to understand Cunningham recklessness is by looking at two applications of it. So let's start with R and Stevenson, 1979. What happened in this case? Well, there was a schizophrenic man, he was the defendant, and he lit a fire inside of a haystack. I think he was cold and he was homeless, he had nowhere to go, so he went into this haystack and he lit a fire and to go to sleep. However, this ended up burning down the whole haystack and everything went up in flames. Now, to a reasonable person, they would be able to foresee this risk and therefore they would be reckless because it would be unjustified. However, the defendant was not convicted because he was schizophrenic, and this was taken into account that he wasn't able to foresee the risk. Therefore, he was not aware, and therefore he was not reckless, and therefore you couldn't say that criminal damage actually occurred here. Another example is R. and Parker, 1977. What happened in this man was having a terrible day. I think he missed his train and he got off at the wrong stop then, and he was having a terrible day, but that's not really important to the case. And what happened is he went into a phone booth, a public telephone, to make a call, and he slammed down the phone. And he wasn't thinking about the risk of doing criminal damage. He was just having a bad day. However, the court said that he did foresee the risk of criminal damage because it was at the back of his mind when he did that action of slamming down the phone, and therefore they could find Cunningham recklessness. Again, it's still subjective because you can see that the person is capable of understanding that if they did this action, that would result in criminal damage. So it's still a subjective test, and these are good ways to see how the Cunningham recklessness test is applied. Another key issue which is looked at when you look at the Cunningham recklessness is that of intoxication. So what happens if the defendant is voluntarily intoxicated, so they've taken by their own means some alcoholic drinks or some drugs? Well, they are not actually allowed to rely on the intoxication as evidence because that they did not foresee and therefore they weren't. It doesn't apply. Essentially, what they have to do is they have to see whether they would have seen the risk had they been sober because they had become intoxicated by their own means. And also there's a case, I don't remember what it's called, but essentially the guy, I think, was drunk and he climbed on some railings in a club and then he fell down and he squashed a woman, causing her injury. And they said you cannot rely that you were drunk and therefore you did not foresee, and you were still reckless, because if you were sober you knew that standing on those railings you would fall down and hurt this woman. So that's basically Cunningham recklessness in a nutshell. And then we'll talk about Caldwell recklessness, which is when the case of R and Caldwell came, the whole notion of Cunningham recklessness changed, and then recently it's gone back to the Cunningham recklessness test. I hope this helps.